abusia honorable Matthew Nyindam Kpandai abusia omo MP MPP MP abusia fo ene update sonko bi aba abonten a efa papa yi ho update sonko bi aba abonten a efa papa yi ho na abusia we dey ma me kasa wa mam kasa tete pese ekọ na ekotie enkoma aba papa yi echese enkoma aba abonten a efa papa yi ho yentem na sese ha eda so aye be media jecha abusia be so wa se ene dey kan ni channel so a ye be so wa so be subscribe be like na abusia wa bo so ahema for person be tie no anya bi atie ye da se
asemi ba metrim se da bi amenya on nka mebusa na nyame nchade na wa be so the by election e do by
no kwasa
eti mete Kpandai say by election in Nyamba so na say amonhwa kwete MP mame. How did you feel?
Well, so we chia kwete phobia. Kpandai, yes. Kpandai nsem no bebre na ne akwatia ese papa. In fact, na wie ye kra wo Supreme Court no decision na omo base wo so kese pa ya akwatia case no. Coincidentally, no, Akwatia case, no, me na nam ye lead counsel, MNDC candidate Yera Yadom Wache. Me nam di lawyer for him, edifi, Kofredia High Court, Akopie Supreme Court. Iti minimum 7 years pa. Na adi ade Kpandai ensemi ba ye ya batu na se captain. Nsam no nipa bi nchiremu ye.
Kpandai issues no.
Nipa nchiremu ye. Onim. Kpandai asem no ye ma yewura eko file petition no ene nsem om de kodan high court wo Tamale no obo ne tofa na asem no nia ne se yato abawie emra no kan CI na ekire ekwan a yemfa abato no nkeka bomu a ye de be declare results no yemfa mfa so ACI 127 no a chese se ena se o kan election petition course wo Ghana Supreme Court 2013 na ka se omoma judgment no se o won sembi fa results ne ho a first and foremost eso raise wo coalition center na polling station o raise na se ne course no wani anje ho ana se ne om resolve wani anje ho a captain na de ato aso e de akọ high court. But this is what happened. How Kpandai no? Di jumani ni awie na NDC candidate no ewo issues wo polling station over 40 ho. Enu nti o ma prepare say ye coalition center on be raise wo ho. Na electoral commission ahwe. Anajo na electoral commission penifo. Omunim say captain ka studio ha na ye ba be coalition center because emra no say e define coalition center to be a place electoral commission ajia tumza hania no watro de ama candidate ne sa hania be coalition center nti muni amunhia yen wo anadona na electoral commission for so ma sesa ba bi ayeye coalition no e de akọ ba bi NDC candidate no onim eno mo akọ ye no mkọkọ ye coalition e declare ye say yewura Nyindam na win election NDC fo ni ho tienie
some of na koye
sasam na ase nia no NDC phone ho no mkoko declare say ya wie bibia pin sheet ni ya wie declaration sheet ni nti ya wie NDC ni no eni ho nso ma declare. So now the NDC candidate went to court and no challenges said no amongst me won some 40 polling stations over 40 something, but you see and some no I should have been given an opportunity ewo year coalition center ho na me raise ho coalition center they call baby aminim ni do obi ani ho and omakwa declare o baby eti emre nia nso nia sombo pa cha emre bia the right to be heard enyane root efi bible say onyankopon kran sana obua Adam for no obisa no no tie no eti the right to be heard na ye principle ye cardinal ewo law eti court no hwe asem no hu say no kwasem ne say the right to be heard no was breached. Ma ne kwan na so we issue kra wa raise wo ho no na court say on the basis of that declaration we twem enti no monko ye twa declaration mu a obi anya MPB enti enkoto aba no fofo. Now in the file a petition on sometime 2010 no na let me say this say o court time rano see I ne ka say you gazette result na answer But you see, that is a presumption. Sebi. Obian ho me ma file a petition. I the highest apex court. Obian ho court or crack gazette notification. Say a gazette answer. It's a presumption by a rebuttable. It is a way lawyer on the other side now person who raise issues say young gazette here. What said yes will be raised because normally a 2 about by 7 year 2 by 9 year declare. It is normally electoral commission by a check by 15-20 before and the Christmas normal gazette results. So Mr. Daniel Echo file, Honorable Daniel Echo file in the petition. Now came, and I have the document here. Now came the MPP candidate who filed processes or no etrimuno or say sa 23rd na Yewra Daniel file a petition sabreno near gazette results intino or filing prematurely into court and wasem into and of file a affidavit de cramming and the car na metro what there and or they call down Tamale High Court. Enti lawyer and file you on behalf of Mr. Nyindam and of file and at the bar some lawyer for the which is a lawyer file there. And then say an official document imagine I can say a fake. Enti ye who this lawyer be yes sir. Enti ye dey say na fan. Enti Mr. Daniel lawyers no who near Yewra Nyindam ne lawyer for file say attach an exhibit of a gazette. This is what they filed in Tamale. Say ye gazette Kpandai election results on the 6th of January. This is an exhibit. Captain here exhibit JSE3 way in Tamale High Court. This is the exhibitor. This is the official gazette. Omanfa we view. No, the photocopy be saying they attach it. These are the records in the Tamale High Court. It's here running who no say, hey, say na your gazette results na file a petition. Oh, yeah, not just a no withdraw. Ne petition our filing because when you 6 ninti and now kind affidavit na me kind mun sem bia chew and no withdraw ye nti o withdraw ye no cost start kind 21 days from 6 because you say oh Mr. Nyindam a former member of parliament and then a lawyer for ya training the omu nditro nti no na or withdraw ye and no start kind fee on the 6th of January 21 days no go file a petition after 21 days one carry ye di asem we ye gina dakam ye bisa in fact electoral commission panyin no gina dakam ye bisa ne say ye den na osesa collation center NDC ni o say na ntokwa bi asi wo ha and na say no senti unanso de kire NDC okbo mama ne say ye sesa ne de akọ baby foforo ye wantimi en ya na judge say no ti bi am ko ye ni anu mu ni ho ni ntimi nji we ntu eti judge no aye bibia wie amotemu bi one raise issue bia and ye judge na man judgment we na a fa election petition for parliamentary hono and can see what court of appeal and Supreme Court.
That's right.
But you see with this one near kwai say omo hu say some kwai appeal on lose because facts cause for election no say o man ye ma bi because appeal me besa hwe adanse a mo de ba high court na so they then decided say no ye nya say yen hwe technicality bi ohwa no mo say eh da bi ye krade na ye de call 6 January no kra nya papa na emom no akwatia case a ye ya mimi di anim no court no ama this is the ruling of akwatia court na ka e wa ha no me kan ba bi a chew say yen gazette na e wa ha Ghana nia results wo no 24th December na nye 6 January no more MPP for Yewra Gary ewo mu bi ono so challenge say ye 6 January no yen ye ka say 24th ma court ajatum afei omo na de 6 ko no ma dane omo ani e say 24th na ye papa enti no say no 24th December and the date for gazette nti at the time Yewra no withdraw ye no sa ko file based on 6 January there no he was out of time as omo BT no captain what you say omo BT no say we ko file no after 12 filing about 31 days because on the after no more kan fi 24th na e original no more 6 so fine Now the Supreme Court looks at it and says, on the face of the record, no dear, because of the Akwetia case, no maka, and say 24th December, next of filing out of time. That's the majority decision of the 4-1. Yenya reasoning, no, ye train, say on the 6th. But I suppose to say the 4 no echo with the strict interpretation say on the previous way no really no. And now back on the case because you see, I disagree with the Supreme Court and they say the court now as we call the Supreme Court only exercise a supervisory jurisdiction and no more ordinary jurisdiction now there be supervisory no as a court ketua bia ye bibia etiam rapa and wako into kwa no sa no to be question right judicial review. Now this is it. It is a discretionary relief. It is Supreme Court no etnase omo hwe bibia fa asem no ho ansa no ma granted ni oma ka kire oma kire wo law school no including o conduct inti Captain Smart se sebe ukobokro no de yade na so the Supreme Court ho na wasem o de crap insan kro no na oboy inti omo granted sa relief ne ma ye cause a discretionary relief ase no so I'm amazed say uhwe sa ene nyom file wo Tamale High Court in copy ni on the 6th of January. I'll tell you something. Electoral Commission case na me ye no. Sa pet yi say ye bi the buy. Maybe them challenges say nya no kre. Ye throw letter come Ghana Publishing Company. Ni nia court no in a ruling no court no my decision no American actual. It turned out say Ghana Publishing for nye gazette bia 6 January. Electoral Commission and Kasanso by Supreme Court because say omonso enye gazette bia 6 January. So now the question we keep asking is say ehen na munya 6 January gazette notification ya mo de kwada High Court Tamale munya ne. And that has been a bone of contention. And it can never happen in this country. Say you be di ahe na baby ko munya asade we no. Omo de afase ye ne. Omo no tres NDC for na echinchim obinsa. Sa asem no so person hu asem num no kra ye nkodi asem no. Ne course wa battle in fact technicality. But if you decide to use technicality sanya Supreme Court mo this idea we call dada ye wura no na mo withdraw ye na fe mu ma de na mo de buy mo adwane afi ho. I've listened to Mr. Nyindam a couple of times our media ubisa no say o ho de yatra ho ubisa say trade we unya wo he a o say o yatra ho Supreme Court akasa sir this is a criminal offense.
Hey
yes perjury. You don't when you file an affidavit, this is the affidavit. When you file an affidavit evidence ubisa lawyer be obeka.
Okay.
It once you file it, evidence. And perjury, nene say, so we file it at the court. Ah, we names are there in your papa, and your no cre. That's how we the Kodan court, perjury. Perjury is a second degree felony. And trust me, this matter is just the beginning. Assuming, say,
Supreme Court
no, because the Supreme Court did not have that jurisdiction. I've heard people talk about fraud in the idea is a Supreme Court area. Because Supreme Court exercise only a supervisory jurisdiction. And the supervisory jurisdiction, either the right to be heard and excess jurisdiction or lack of jurisdiction. And so, of course, you can, and Supreme Court is it's a very, very smart court. You see, because only the apex court. But said here for now. What we need to do, the angle will. No, because let me read something to you. They filed a similar one, also from the ruling, also from the High Court upwards to this court, the crux of applicant's case, remained unchanged. It was this that at the time the petition was filed in the High Court on 31st December 2024, the results of the parliamentary election had not been gazetted. They are similar.
Okay.
The results, according to him, was gazetted on the 6th January 2025. Let's say we are. Omo say it was gazetted on the 6th of January 2025. By law, no valid petition could have been filed. In effect, the petition of 31st December 2024 was incapable of invoking the jurisdiction of the High Court whatsoever. Consequently, all processes filed by the first respondent, the first interested party, and all other rulings was obtained. He obtained upon the petition in the trial are void. And all catcher or say, or say this provision is devoid of any ambiguity a person seeking to, what I mean, also with the crucial facts established, the applicants, yes, or say, a petition seeking to challenge the results of the parliamentary elections on grounds save an allegation of corrupt or payment of money or other reward on behalf of the one being challenged or his knowledge shall be presented within 21 days. No debate turned on the fact that the first respondent party was challenging the results on grounds that corruption of payment of money or reward was given. The petition presented on 31st December 2024 was within 21 days after the publication of the Gazette 2024. Because now the Supreme Court established to say there was no way ombetimi edes adewe ababa kase papa. Now, the central issue in this case, therefore, was when was the result of the Akwatia parliamentary election gazetted? This could only be a simple question of fact, even though the Gazette notification carried the legal effect. In his affidavit in support, the applicant attached Exhibit D as an extract of Gazette notification. On the extract, the date of the Gazette was stated 6 January 2025. The interested party filed a further supplementary affidavit in opposition on this date and exhibited this. The Electoral Commission, a second defendant party, filed an affidavit to which was attached a Gazette, the same as Exhibit 11, filed by the interested party. From the affidavit evidence, finally, before this court, it was established that the Gazette notification of number 234, dated 24th December 2024, was the valid one. And when he copied we therefore had no difficulty finding that the results of the Akwatia parliamentary elections were gazetted on 24th December and not 6 January 2020. So this is exactly what it is. It is as 6 January because Captain Unim say Oman Fasa we ankoda court na and Mr. Nyindam Mr. Daniel Ipanka on withdraw the petition. When normally call Tamale High Court, the already draw the initial petition. He received
on the 6th normal Gazette results.
Yes, or no chase on the 6th, no magazine or more Gazette on the 6th. And that's all filing the 23rd, and that's all filing in Gazette. So the question now is, sir, when this is a photocopy of what they filed in the Tamale High Court. We will not let this rest. They should tell us where they got the electoral commission. So many publishing forms. So yes, so many more. But you they should tell us.
This is your name.
And on what I'll say, the second interested party filed an affidavit to which he attached a Gazette, the same as Exhibit 11. Exhibit. This is Kpandai Npp. To any original, no. Na me kire onia ma bi wo hwe eniam omo ye no ho na kroi mu ho eyi Kpandai ni
na hu se Kpandai sho
good Kpandai is in hwe number no
8123
good hwe ade wa ha enya clear papa but obe hwe ade
ma me
hwe ni ye na dasoro
esoro hin
Kpandai ni
na ono so number na was to hase no mo me twa na ma zooming out to the train abotama edwuma ya no Abba. Oh, you no said them. Ghana Gazette 24 December 8123. Okay.
It has a page, and I'm reproduce here. And now, into the Captain on the date, we are saying
7 December.
There be 7 December, no year results. But date on the year,
24th December.
Into who's also Hannah. And yet, but I say, we
any 7th, the show. 7th December.
They throw at you.
What's that, man?
Miss Mitchell.
We're lawyer. Oh, I never tell me the way.
Captain, Ren Kofu, we Omo, Adia, Kofu, wait to me. Now, the same thing on here, Wakwetia, and two back to Sakwetia. You see, you know what happened? After the court ruled, we had filed a criminal way against Yura and Escumi. That's the truth. Say, Ometre baby, Onya, Sa Gazette, you it's back and forth now, Yankopon, a ton suffering. It's unfortunate. But the same thing, and I'm filing what all the cases are, and this is the court, you know. It is the same. The Supreme Court has not even, and they don't have the jurisdiction to go in to say, Obi we are Bemo and Obi we are almost head data there. It is say, when on the court other court now, a man, Mr. Daniel, no, I would
say, and true, that's just what other court, and a document, and also genuine
for fraud, no, it's fraud and perjury, and both are second-degree felonies. If you are convicted, you can never be an assemblyman ground debut because it borders on morality.
Enti ade we no munje mu
Captain what the some week ya na Supreme Court today omo reasoning ne beba yan hwe ne ebesi
Dedi kama amena pending TV ase na so far so good say open online portal e wo Ghana nipa share nipa follow nipa comment here to my best of knowledge without any biases pending TV